Your next witness, please.
Thank you, Mr. Chair and members. I'm Michael Malter, Senior Partner of Binder & Malter, a 9-attorney bankruptcy firm in Santa Clara. I've practiced bankruptcy law for 35 years, representing both debtors and creditors. I'm a certified bankruptcy specialist and a 15-year member of the adjunct faculty of Santa Clara University School of Law. I'm here in very strong support of SB 308. Prior to April 2012, if a debtor's home was sold after a bankruptcy filing, because the debts in the bankruptcy were being discharged, the debtor received the homestead funds from the bankruptcy trustee free of any requirement to reinvest the funds to another home or a time limit to do so. That was the state of the law for 35 years. That changed in April 2012 with the Ninth Circuit decision of In re Jacobson, which held that the 6-month reinvestment requirement of CCP 704-720B applies to sales after a bankruptcy filing. This change has worked a great hardship on many debtors who can't reinvest the homestead proceeds because they can't get a loan after a bankruptcy filing, or they need the funds for another purpose. One such case involved my clients Frank and Joanne Cope. The Copes were residents of Portola Valley who were in their late 60s. Frank had been very successful in the boat business with his company Cope and McFeeters, but the boating industry was one of the first casualties of the economic collapse of 2007. Additionally, Frank suffered 2 strokes. The businesses failed, and because Frank had personally guaranteed a large amount of the corporate debt, he and Joanne were forced to file personal Chapter 7 on November 20, 2010. After the bankruptcy filing, Frank was diagnosed in early 2011 with prostate cancer. At the time of the bankruptcy filing, the Cope's sole source of income was Social Security. They had an IRA in the amount of $20,000. But they also owned their home in Portola Valley, which they had had for many years. And at the time of the bankruptcy filing, we valued the house at $3.3 million, with $850,000 of debt owing against the homes. After the filing, the Copes fully cooperated with the Chapter 7 trustee and the marketing and sale of their long-held home. The house was sold on September 26, 2011 for $2.35 million. Because the Copes were over 65 and Frank was fully disabled, they received their homestead funds in the amount of $175,000 in October 2011. They moved to an affordable rental home in Manteca, where Frank continued to receive medical treatment for his prostate cancer. The Jacobson case, which I earlier referred to, was decided on April 27, 2012. The Cope's 6-month reinvestment period ran on April 24, 2012. On April 27, the Cope's Chapter 7 trustee demanded the turnover of $175,000 from the Copes because they had not reinvested in another house. At that time, only $37,000 of the $175,000 remained because the funds had been used for Frank's medical treatments as well as to cover their living expenses. These remaining funds were desperately needed by my clients for further medical and living expenses. On July 9, 2012, the bankruptcy court ordered the turnover of these remaining funds to the Chapter 7 trustee because of the Jacobson decision. The court could have ordered...
Sir, we need to wrap up quickly.
Okay, I'm sorry. The Copes had always looked to their home as their resource in time of need. The house was, under this decision, not available and increased their suffering. I urge the passage of SB 308. Thank you, Mr.
Thank you. We have another witness.
Larry Doyle on behalf of the Conference of California Bar Associations. We strongly support Senate Bill 308, particularly those provisions that increase the homestead exemption to a more rational and fair level. Thank you.
Thank you. Anyone else in support? Are the witnesses in support? Seeing none, witnesses in opposition.
We'll call you back. You can sit up here.
morning, Mr. Chair and members. Alex Alanis with the California Bankers Association. So the increases that are proposed in the analysis, I guess Mr. Wachowski will accept those, are still very high. They do increase the tiers by 133%, 150%, and 71% respectively. These are still very high increases for equity in a home. Now, you've heard testimony about home values, but that's not what we're talking about. We're talking about equity in a house. And the increases are significant because the purposes of it is really just to, like they would say, get back on your feet and then reinvest it in another home. But to take the money essentially and walk away with cash and there's no requirement that you use it for shelter, is really just giving someone the opportunity to shelter their funds prior to filing for bankruptcy. If you see bankruptcy coming around the corner, a wise bankruptcy attorney could actually advise their client that you might want to start putting your money in places in which won't be available for creditors. This is a big cash pot for someone who wants to not pay their creditors and put it away in a place in which is not available. This is one way in which someone can walk away with cash. So these levels were increased, I guess, in 2010. They took effect in January 1st of 2010. Each of the levels were increased by $25,000. And so if he was looking for a more modest amount, something in that area would be helpful. But these large increases really are just helping people who have means. This is not about the $20,000 a year person we're talking about. We're talking about someone who has means, who has the ability to pay their creditors, and in some instances don't want to pay their creditors and are looking for ways in which to shelter their money. It's not disputable that they could pull this off. So we would recommend that they not move forward with the measure. Keep the 6-month requirement. If the committee thinks that 6 months is too short of a time for someone to get in the house, then we don't think that elimination of the 6-month time period is the answer. Maybe a longer period, maybe 1 year would be more helpful for someone to get on their feet. But to remove the requirement for them to have to put the money into a home is not helpful, and I think it's counterintuitive to what the purpose of the homestead exemption was made for. There's other provisions in the bill which we have concerns about, the $5,000 in the small business. There's no requirement that the money come from the business account. You can actually take the money from your own personal checking account and put it into your business account and consider that to be your $5,000 exemption. The vacation pay definitely could benefit those people who are higher income. They definitely are paid at a higher level, and if it's time to cash out, they could walk away with a lot of money in income, and they could have several days of vacation that was available to them, but that money would not be available to worthy creditors. And then finally, the issue of the separated spouse. You've heard one story. I'll tell you another story, which I've heard from folks, that the opportunity could be that you could be somewhat vindictive to your other spouse, whereas since separated is not really defined in the bill, you could claim to be separated prior to bankruptcy. You can then no longer be necessary to take the waiver from your other spouse and decide you want to go ahead and file bankruptcy by yourself, not needing the waiver, file a 703, which then you can claim your personal property exemptions and walk away with your boat, leaving your spouse with the house and the debt related to it. So it's definitely can be used for ways in which to be vindictive. You've heard one sympathetic story, but there are other opportunities for people to walk away with the benefits of the personal property exemptions under 703 and not need the waiver. So for those reasons, we urge the committee to vote no today.
Thank you. Next witness, please.
Good morning, Mr. Chair and members of the committee. My name is Howard Ehrenberg. I am a certified bankruptcy specialist and have been practicing since 1986. I am on the panel of Chapter 7 bankruptcy trustees for the Central District of California, which includes Los Angeles, since 1995. I've administered more than 10,000 cases in the last 20 years. The purpose of exemptions is to enable a debtor to obtain a fresh start. In 2009, this legislature adjusted the homestead exemptions by $25,000 for each tier. Now, just 5 years later, not many years later, SB 308, even as recently amended, seeks to increase the individual and family exemptions by $100,000 and $150,000, increases of more than 133%. The only people who would be benefited by this bill are wealthy debtors. Remember, we are talking about exempting the equity in the home, not protecting its overall value. The vast majority of bankruptcy debtors do not own homes. They get an exemption of approximately $25,000 in personal property, including cash, which equates to approximately a year's worth of rent. SB 308, even as amended, would give homeowners an exemption in cash of $175,000 to $300,000, or 7 to 12 years of rent. That is not a fresh start. That is a windfall. Homeowners with up to $300,000 equity should not be able to keep such a large sum on top of the many other exemptions California already provides while attempting to discharge their debts like credit cards. The proposal to remove the requirement that the proceeds from selling a homestead need never be reinvested is particularly unfair, as it defeats the purpose of protecting the home itself, but creates a protected pile of cash as large as $300,000. That is not a fresh start. That is a windfall. The trustees believe that the existing set of homestead exemptions creates the proper balance. But if adjustments must be made, we suggest that they be limited to $25,000 per tier, as was done only 5 years ago, and that the reinvestment period be expanded from 6 months to 1 year. We do not in particular oppose any other provisions of the bill. And I would like to mention that Senator Wachowski discussed fraudulent conveyances. That is not the issue with respect to debtors we're talking about. What we're talking about is exemption planning. Debtors can take money out of their bank accounts, pay down their mortgages to create a $300,000 amount of equity, then file bankruptcy and exempt all of that value. It is exemption planning. It is not illegal under the bankruptcy code. We are not talking about fraudulent conveyances where I would attempt to seek to recover the conveyance of those funds. I'm happy to answer any questions.
Thank you. Your next witness, please.
Tim Lynch on behalf of DBA, the trade association representing debt buyers, and we remain opposed to the bill for the reasons stated.
Thank you.
Mr. Chairman, Cliff Berg for the California Association of Collectors. We are opposed to this bill. We think it just creates a roadmap, as you've heard, for affluent debtors to avoid, in essence, concealing their assets from creditors.
Thank you. Other witnesses opposed, if you could just give your name, your affiliation.
David Quintana on behalf of Encore Capital Group. We are opposed.
Thank you.
John Menchaca, Chapter 7 trustee, certified public accountant, certified insolvency and reorganization advisor, in opposition of the bill.
Thank you. Anyone else opposed? All right. Thank you. Bring it back to the committee. So, Senator, maybe you can address some of the concerns that were raised. And I think that while your opposition, I think, framed it really well and tried not to be heartless in this conversation, if we are looking at the lower income ranges of debtors in this case, and we're also working pretty hard to pull people out of poverty in the state of California and making sure that we have a system that doesn't unnecessarily put people into poverty. But at the same time, recognizing the legitimate interest in the fact that there has been a debt accrued, and that debt is then owed to a banking or credit institution. Can you talk a little bit about what the opposition brings up and make sure that we're not creating, as was said, a windfall situation, but really fully setting up a system where people can get a second chance, really have the opportunity to build back, not fall into poverty, not then fall into the need for social services or other services in California, but then really start over?
Sure. We haven't kept, the theory is that since the modernization of the bankruptcy code in 1978, we really haven't paid attention to the unique situation that we have here in California about the rising value of our homes and the exemption that we had set up there. At the time, as my witnesses testified, the exemption for an average family was $25,000, and the average home was $40,000. Right now, the average home in California costs $440,000. We're not even even with a married couple, it's about half of what would cover versus a quarter of it. The equity rises in the house a lot of times because of the zip code that you have, right? And a lot of these people are working poor that may have some equity in the property, but it's not a bundle. I mean, think about $75,000. In every place that everybody lives right now, $75,000 is in many ways meaningless for a protection given the rising prices in California. It's nothing that the debtors have done.
Right, but distinguish the value of the house versus the equity in the house that somebody may have.
Well, the equity of the house is remember, the trustee Ehrenberg, is his job, and the trustee that was here, their job is to liquidate assets, right? So right now, there's a scenario where trustees can hold estates open and wait for the prices of the houses to go up in order to liquidate the houses, to pay unsecured debt, right? You have a situation where debtors may have a modest value of their home, a modest equity amount in their home, but because of the turbulent market out there in my area, people overbidding for houses, the trustee can put the house up for sale to force the sale of the house with a very modest amount, right? The idea is that person becomes homeless at that time, right? And they're given this $75,000 amount. It was never intended. Most of you, when I talk with you, think that the homestead protected your home. It only protects this small, minor value, and it really small, not minor, but $100,000, $75,000 in your house, and doesn't really allow the debtors to feel comfortable about opening up their assets to the trustees who will sell it. I mean, I don't know if
Thank you. I'm going to open up for other questions. Mr. Wagner?
Yeah, I detect, to my mind at least, a little bit of an inconsistency in your argument here. The concern, and if you can address this, you talk about how we've got these rising values of the homes, and it's based on zip code or for whatever reasons it is, and we haven't had the homestead exemption keep up with the rising price of the homes. Okay, I'll accept that. Then why do you come along and divorce the homestead exemption from shelter, from home ownership? If we're trying to keep pace with inflation, we're upping the exemption because it now costs that much more to go buy another house or find other shelter. You completely divorce the two issues by no longer requiring that it be reinvested within 6 months. So the argument you make doesn't help you with the cause of your bill, which is divorcing the two.
I'll let my witness testify.
Because I got more after that.
No, I want more.
But there's an inconsistency at the heart of your argument.
So, Assemblyman Wagner, the problem was created on the reinvestment issue by this 2012 amendment case. Up until then, bankruptcy debtors could file bankruptcy. If their house was sold during the bankruptcy, the proceeds were exempt. There was no reinvestment requirement. For 35 years at least, the debtor could keep that money. And the distinction is that Section 704, which is the section that provides the homestead, applies to debtors both in bankruptcy and debtors who don't file bankruptcy. The reason for the reinvestment requirement in the first place came about to shield home equity for people whose claims would not be wiped out in bankruptcy. They would file the exemption, and if they had a creditor collecting on a debt, they could shield that much equity. If the house were sold, the creditor's claim, which didn't go through bankruptcy, was still live. The debtor had 6 months to put that money in another home and continue to protect it from a live claim. The reason it wasn't viewed as applying in bankruptcy was In bankruptcy, the creditor's claim dies. It's cut off. It's discharged. The debtor is supposed to get the fresh start. So the purpose of enforcing a reinvestment requirement doesn't exist. In Mr. Malter's client's case, they needed the money for cancer treatment. There's no reason that it should apply to bankruptcy clients and did not apply until this Jacobson case. So we're trying to correct that inequity.
Well, go ahead.
Things have changed in the market, because of the recession. Now, FHA will not even consider you for a loan for 2 years. Freddie Mac and Fannie Mae, it's 4 years. There's no community banks. The banking industry got rid of the community banks. There's no place to go. Even if you had the $75,000, you could never find somebody that would. If you found the house, nobody would loan you the money. So that's another reason where you say we never anticipated that unsecured debt by credit cards, medical debts, would be used to collateralize a person's home. That's why it is unsecured debt. In a bankruptcy situation, you're selling assets, but the public policy is supposed to say, we're here saying the public policy is that we want to protect people's homes because we encourage home ownership. I mean, Oklahoma has, it's not exactly, they have an unlimited homestead exemption. They say and their average house of their home is $121,000. They say in Oklahoma, these creditors, a trustee does not get to take the home in Oklahoma. You've got, Massachusetts, which is close to us. They have $323,000, but they're at $500,000. The public policy says that we want our consumers to keep their home and not become charges of the state.
Correct, and that's the point. And what we're hearing here is that the Jacobson court got it wrong, except I don't know that there was any appeal of the Jacobson court. You're not here asking us to undo that opinion. What you're saying is the public policy is protect home ownership. Oh, by the way, my bill is not going to require that they go out and now go get a home. My bill is not going to require them to get shelter. So maybe like the chairman said, they may end up on the public dole. They may end up in public shelter. You don't get it both ways. You can't say let's get rid of the homestead, the requirement from home ownership, but at the same time we're promoting the public policy for home ownership with this increase of the homestead exemption. Those two don't work together.
If we went to an unlimited homestead exemption, I would withdraw the Jacobson reinvestment. If we went there, because when I introduced this bill, I read in my local paper in Fremont, California, which is nowhere, the average home price was $700,000. That's why I chose $700,000, because I said people should get their house. The prices are crazy. In April, it went up to $900,000. Last week, it was $1 million for the average home in Fremont, which is nowhere. That's $300,000 because we happen to have a great school system that people are overbidding, and the average person who would have come into my office in December with no equity in their property, no equity, here's the appraisal, somehow magically 6 months later, and it's his job to sell the house.
All right. I get that housing prices are going up. I understand that, and I can see that as a justification for raising the exemption, perhaps, if it then tracked home ownership, but it doesn't. You just say, I don't care what you use the money for. So that's the inconsistency that I'm seeing here.
But wait. The idea. Remember, the idea here in raising the homestead exemption is hopefully that the house doesn't get sold. The idea is here, we don't want the house to be sold. We want somebody to come into bankruptcy and say, I have $76,000 worth of equity, and the trustee saying, okay, that's not enough to pay off your creditors. I'm going to administer the case, and you can keep your house, make your mortgage, and stay where you are.
Which raises the next problem Mr. Alanis brought up, which is using the house as the money pot. Now, those of us that own homes know the movie Money Pit. Mm-hmm. Well, this is a clever play on that, and now it's a money pot where I'm dumping money to protect it from what everybody says are legitimate debts.
Right.
How is that fair?
So, if I might respond again, Assemblyman Wagner, you could find a scenario, and the California bankers, I'm sure, could create a picture of a bad debtor that's doing this. And there might be somebody who abuses the law today, tomorrow, 20 years ago.
But that's not an abuse of the law.
Well, you're picturing it as an inequitable situation. And
Yes,
what
I
we're
know.
saying is when my client comes in now and they have $100,000 equity in their house, and the house is worth or appreciates during the bankruptcy, so it's worth $150,000. The bankruptcy trustee today can force the sale of that house, give my clients $100,000, watch the clock run out, see that these debtors couldn't buy another house with no credit, no mortgage lending to them, and then after 6 months collect this $100,000 that they got. Both things. If we increase the dollars, as Mr. Wachowski has said, it shields the house from the forced sale. We're not trying to recover cash from the house. We're trying to preserve the home. But if it's sold, there'd be enough money for the debtor to possibly buy another house with.
Here's the other bit is okay, conceivably somebody meets the means test, because remember when you file a bankruptcy you have to have a certain threshold of income that you don't have the ability to pay back your creditors. So let's assume that you have this person that fails the means test, so they're eligible for Chapter 7, right? Then somehow they magically had, so that means in the last 6 months, because we go back 6 months, in the last 6 months they didn't earn enough income to pass the means test. Then the concept is that it's not a fraudulent conveyance, but it is a pre-petition planning that the debtors have moved money into the value of the house to reduce it. They still have a challenge, and I guarantee you the trustees and the banks are going to challenge that debtor in bankruptcy court for filing that case in bad faith. The judges still get to do the smell test and say it doesn't pass the smell test, and that case was filed in bad faith. You still have that, and by the way, with the changes in the Bankruptcy Act, debtors' counsel is challenged to give legal pre-petition advice, because the U.S. trustees and the trustees ask, were you advised to transfer any assets prior to the filing? Did you move any assets around? That's disclosed, so it's not a big secret. Right. That minuscule opportunity is absorbable, giving all the other bad effects that people are going to be losing their houses.
Right. Let me thank you for the time you spent with me beforehand and the conversation. Trustee Aronson looks like he's trying to get in and say something, and rather just say, tell me what. Let me ask you this: what's wrong with maybe going out to a year or 2 years, or pick a number, or maybe allowing for some judicial override? The debtor comes in and can explain to the judge why they can't find a house, or they should use the money for something else. Does that help?
We can't change the bankruptcy code. We can't change the bankruptcy code because it's federal law. And I said in my remarks that I'm not against enlarging the period from 6 months to a year, or even if there were discussion longer than that. If I could just make 3 quick responses to the senator. The first is...
No, you can answer the Assembly member's question.
I'm sorry. Okay. The answer is there's nothing wrong with enlarging the reinvestment period, and we can't create a judicial oversight in the state because it's federal law.
Well, if we're able to increase, if we're able to increase the year from 6 months to a year, or even from 6 months to 2 years, can't we say we're going to increase it from 6 months to a year if the judge approves it, and kind of backdoor it that way? That's not changing the bankruptcy code. That seems to be within our power. Hang on, this isn't for you. Sorry, thank you.
Yeah, I don't believe we can.
No? Okay.
California has opted out of the federal bankruptcy system and has created its own set of exemptions, and the bankruptcy courts honor those exemptions but can't be told how otherwise to enact them.
Mr. Chow.
I'm just wondering, since the Jacobson decision was handed down, how many debtors have not complied with the reinvestment requirements, either because of the fact that they can't qualify for Freddie or Fannie, and how many of these debtors have done that? And the follow-up question is, in those situations, has the trustee actually gone after the debtor and collect the exemption amount?
The answer to your question is almost none, because the debtors can reinvest the money. Senator Wieckowski talks about inability to get an FHA loan. FHA loans are where you don't have any money and you only have 3%. We're talking in this discussion about a debtor who has $300,000 of net equity from the proceeds of the sale of the home. That person is going to be able to get a loan against another house, because if you put down 25 or 50%, you're going to qualify for a loan regardless of when you file bankruptcy. We're not talking about FHA where you only have 3%. And so the answer to your question is, I have never found a debtor in my 20 years whose home got sold who could not reinvest in another residence within the time period, because they know that they have to. And sometimes, as people who file bankruptcy do, they have to step down in the size of their home. They're not in a home anymore. Maybe now they're in a condominium. And if they had $175,000, they could actually purchase outright the condominium and have no more debt. But what we're talking about in this bill is to create an exception for a micro subgroup of debtors. Remember, 98% of all debtors who file bankruptcy have no assets at all. I administer assets in less than 2% of the total cases. And the percentage of those who have in excess of the existing amount of homestead exemption is almost nil. So we're talking about creating a benefit for a micro subgroup of the people who file bankruptcy.
I would just say it's the exact opposite. I don't think that there's
You'll have an opportunity. Yeah. No more questions? All right, thank you. The recommended motion is do pass as amended to appropriations. I appreciate the work that you've done, Senator, in this realm, and I think trying to find a balance here between the need to have an enforceable debt and get creditors paid off, but still protect some assets so that debtors do get another chance at being able to become and stay productive in our community is appropriate. So I'll ask you to close.
I realize that I didn't talk about the challenge of the non-filing spouse. And so you understand what the situation is that what we're doing is we're allowing the non-filing spouse to take the 703 exemptions versus now they have to take the 704 exemptions. And the question is that you're going to have a bad actor spouse that would file a bankruptcy and they're in a bad divorce. Well, that happens right now. I mean, the situation is that you can go through divorce and you can give your wife the boat that happens to have $25,000 worth of equity, and then you claim the 704 exemptions. And she doesn't, and you don't have to file the waiver. You don't have to file the waiver. The trustee then gets to go after her for the boat that still has your name on it. What we're doing is we're saying here you can file for the 703 exemptions. Yeah, there may still be the nasty situation, but you can take advantage of the 703 because often they don't have the home and they want to protect their excess equity and maybe a car that they have. I appreciate everybody's indulgence on this.
Thank you, Senator.
I urge and
I'll
I
take
vote.
that as your close.
Yeah.
I'm still looking for a motion. Again, the motion would be do pass as amended to appropriations.
Mr. Chair, I would be willing to make a motion to move this along. I do appreciate what you're trying to get at. I think it's admirable, and I believe, being one of the non-lawyers on this committee, I can certainly sit here and recognize how complicated the bankruptcy part of the law is. And I'm doing my best to follow along with all the various perspectives. I think that there are some meaningful thoughts that have been presented by the opposition. I recognize that as you move to appropriations, there may be an opportunity to further find common ground on some of this. But I think from my perspective, it's admirable that you're trying to get at a place where working class families, medium income families find themselves in. And I know that there are examples, as pointed out, in a lot of circumstances and situations that you could look at all of the extremes, but I think that the courts, I believe, have opportunity to delve into these issues even more so. And your attempt is to try to keep families in their home, from what I understand. And with that, I would be prepared to move the motion.
So there is a motion. Do we have a second? I'll second it.
Thank you.
If you would call the roll.
Stone?
Aye.
Stone, aye. Wagner? No. Wagner, no. Alejo? Chow? Chow, aye. Chu? Chu, aye. Gallagher? Gallagher, no. Garcia? Holden? Holden, aye. Mainshine? Mainshine, no. O'Donnell? O'Donnell, aye.
You need one more. I'll hold the roll open on that since we do have some members who are not voting.
Thank you.